Let's talk to you today about being hit by a hit and run driver or an uninsured driver. Let's start with a hit and run driver. Unfortunately, there are drivers out there who negligently injure someone and then compound their agony by fleeing the scene. The only way to adequately protect yourself from potentially being left with no compensation when such a situation arises is to have been carrying an adequate amount of uninsured motorist coverage prior to the hit and run incident. But we'll now discuss the two potential ways a hit and run incident can play out from an auto insurance perspective. Scenario number one, you are fortunately able to locate the at-fault driver's contact information after the fact, and this driver has liability insurance. This is by far and away your preferred monetary scenario towards achieving a fair recovery. The first step in trying to make this happen is to immediately contact the police after the collision and give as much description as possible of the offending driver and vehicle. This also involves securing witnesses at the scene and possibly video from nearby businesses. Many people do not realize that 911 calls are recorded and can be obtained through open records requests. Sometimes these records contain information that could lead to finding the offending party. Should you be able to locate the vehicle that was driven by the at-fault party, and should that vehicle have liability insurance, you can collect against that insurance for that vehicle. There may also be other insurance policies or liable parties tied to the at-fault driver against whom you could collect. Additionally, a hit-and-run driver can also be held liable for punitive damages as well as your compensatory ones. Therefore, your damages claim theoretically has more value against the hit-and-run driver than merely the cost of your medical bills, lost wages, and pain and suffering. In the event you receive the policy limits for all the liability coverages, you can still collect against any available uninsured motorist coverage you have secondarily. Scenario two, you are either unable to locate the offending driver and vehicle, or you do locate that person and vehicle and there is no liability coverage. This is your worst case scenario and is problematic for two reasons. Number one, the sole extent of your recovery is whatever uninsured motorist coverage you have at your disposal. Unfortunately, some people have no uninsured motorist coverage, and therefore there's no possibility of any insurance recovery. However, even if they do have coverage, it might not be a sufficient amount to fully compensate them for their damages. The second reason is you cannot collect punitive damages against your uninsured motorist carrier. Therefore, the threat of punitive damages you could ask for from a jury if you found the at-fault party and they are a named defendant does not exist when the sole defendant is the unknown John Doe or your uninsured motorist carrier. Note, you could still bring a lawsuit in court if you can't find the at-fault party. In that scenario, you sue John Doe and you serve your uninsured motorist carrier. Your carrier then has the right to either defend the lawsuit on behalf of John Doe or identify the insurance company as a named defendant to the jury. Now let's talk about being injured by an uninsured driver, and you're roughly in the same position as if you were hit by an hit-and-run driver. The differences are only slight. The first thing to remember is that even though liability follows the car in Georgia, there are other potential sources of liability insurance you can collect against. That means the first source of liability coverage is the auto insurance covering the vehicle that was used to cause the collision. Assuming this vehicle was uninsured, it is probably unlikely there's secondary liability coverage to cover the at-fault party, but that being said, it's still a possibility. The first thing to look at is to see if the at-fault driver had any auto insurance policy in his or her name that might cover them. Possible scenarios are they owned other vehicles or maybe weren't even the owner of the car they were driving during the collision and didn't even know that that particular car had no coverage. The next thing to consider is if the vehicle was owned by someone else, whether the owner had valid insurance in his name for other vehicles. The owner of the vehicle may have lent the car to the at-fault driver and may be vicariously liable. Therefore, you want to know what possible coverages the vehicle owner may have had. Finally, you want to know what the at-fault driver was doing at the time of the collision and whether he was on a work assignment for someone else, even if that person or company did not own the vehicle. That person or company could be potentially liable and also have insurance coverage to cover their liability. Now, if all those searches are fruitless, it is still possible you could have a recovery, and that is where you turn to your uninsured motorist coverage. And hopefully you have enough to adequately compensate you.